Hey everyone, welcome back. Today we've got a fresh batch of sovereign citizen chaos to dive into, including an update on everyone's favorite self-proclaimed living man, Eric Martin. After finally getting out of jail, he managed to last a grand total of 2 days before doing exactly what everyone expected him to do, violating his bond conditions. We'll also check in on a repeat offender who still believes he's the victim despite being convicted, and we'll finish things off with a right-to-travel expert who walks into court completely unprepared and gets shut down by a judge who clearly wasn't in the mood for nonsense. As always, the confidence is high, the legal knowledge is low, and the outcomes are exactly what you'd expect. Let's get into it.
This is Mr. Martin. All right, this is 251756, the People versus Eric Martin. Mr. Martin, can you tell me your first and last name?
No, really don't want to give no name, so it's not fraudulent presumed on something else.
All right, well, I recognize you. You're Eric Martin. Sir, you've been brought to court on some charges here. Count 1 and count 2. The warrant alleges on June 12th of 2025 at property located at 9 in the city of Taylor, a foreign complaint in this court was filed against you stating that on that date and location, the defendant, that's you, contrary to law, 1, did make an assault or an assault and battery upon the following person, Lisa K. Martin, contrary to MCL 750.81, parent 1. That's a misdemeanor punishable by up to 93 days in jail and up to $500 fine. He's already been arraigned. Yeah, he's just. Oh, so you know the original charges against you. And part of those charges against you, let's see, you could not have any contact with the complaining witness, Lisa K. Martin. You could not go to the address and you could not have any contact through the phone. You couldn't go in person. You couldn't go to the residence, period. And there's an allegation. I've got a report. You were arraigned on these allegations. It looks like on the 14th out county by Judge Burton. And then I have a police report that alleges on June 16th, officers were dispatched to that location. And there are allegations that you entered the residence through the back door, and were actually in the home at time of arrest for violating your bond conditions. Those are the allegations against you.
You know, if the court tells you to stay away from a specific house, there are probably a lot of places you shouldn't be. That house is one of them. It's pretty difficult to argue that you obeyed a stay-away order when law enforcement literally finds you standing inside the property you're prohibited from entering. For someone who believes court orders don't apply to him, reality seems to keep delivering the same lesson over and over again.
I moved to dismiss the charges because the alleged bond conditions supposedly against me, which is really not against me anyways. Legal fiction, corporate entity defendant, which does not mean I'm a living man. But anyways, besides that issue, the bond conditions violate my right to be presumed innocent before guilty. Because I am presumed innocent before guilty, any bond conditions violate my right. Because if I'm innocent, then I cannot be told you can't do this, you can't do that.
So, Mr. Martin, are you entering a guilty or not guilty plea on that violation?
First of all, I'm not a defendant, so I'm not here to enter a plea. How can I enter a plea? I'm not the one charged.
Okay, then I'm going to say you're standing mute. It's my understanding you've refused to meet with counsel. You don't want an attorney. So I'm entering a not guilty plea on your behalf.
So, okay, well, so have you made the legal determination that I'm not guilty?
No, sir. I'm doing it based on your arraignment. You understand the allegation against you. Do you? I just told you what it is. The allegation is you violated a condition of your bond on an assault and battery domestic violence case by returning to the address after being ordered you could not return to the address.
Well, like I said, I moved to, like I said, bond conditions violate the right to be presumed innocent anyway, so that's no true bond condition, violation is legit anyways. And there's no probable cause for this case. I should have been arrested illegally anyways, because there is no evidence. My sister lied, her allegations are a total lie.
All right, you have a right to remain silent. Anything you say orally or in writing can and will be used against you, sir. You understand what the allegation is? You were just arraigned on it 2 days before picking up this, the original charge 2 days before picking up this violation. Mr. Martin, this is, I hear you. This is standard for you. And I honestly, you won't listen to court orders. You think they don't apply to you. You continue to go back to a residence you've been advised not to go to. You have a $25,000 cash or surety bond with a GPS tether.
Well, first of all, I have a choice. I have another house to go to for one.
The good news is, he won't have to worry about the weather for a while. The state has already arranged a place where the roof doesn't leak, the temperature is controlled, and the accommodations are funded entirely by taxpayers. Unfortunately for him, it's called jail.
Besides violating my rights.
Well, now you do. Now you do, Mr. Morton. You've got another house to go to now. It's
guess what?
Jail. We'll see you at your next court date. All right, thank you, officer. We'll see you next time, Mr. Martin.
Mr. Martin. Okay, goodbye. Have a seat, Eric.
That wraps up this hearing, but don't worry, we haven't seen the last of him. He still has the original charges hanging over his head, and now he's added a bond violation to the collection. It's amazing how some people treat court orders like optional suggestions and then act surprised when the judge disagrees.
I will call the case of the state of Michigan versus Lawrence Buckner, case number 25S00102.
Tiffany Woods for the people.
I'm Public Defender Dr. Lee on behalf of Mr. Buckner. Mr. Buckner, can you state your name, sir? Mr. Buckner, could you state your name, sir?
Lawrence Buckner.
And could you turn on your video, please?
All right, we're here for sentencing today.
Yes, Your Honor, I have reviewed the report and recommendation with Mr. Buckner. I don't believe we don't have any factual modification to the report. I would like to provide them elocution. Shouldn't ask the court not to accept the recommendation.
Thank you. Ms. Woods?
One moment, Judge. I'm pulling up my notes right now. My computer is just a little slow.
Mr. Buckner, are you driving, sir?
No, ma'am. I'm not driving.
Judge, I've also had an opportunity to review the PSIR recommendation, and I'd ask the court to follow the recommendation within that report. Thank you.
Mr. Buckner, why do I hear your blinker on? So
That's my hazard lights.
your what?
That's my hazard lights. Those are my hazard lights.
Mr. Lebo, what would you like to say on behalf of your client, please?
First, I want to note that when I discussed this with Mr. Buckner yesterday, he told me that he understands that when he got upset, when he felt provoked by the officer, he should have kept his mouth shut, and he shouldn't have made any kind of threatening statement, even if he felt disrespected. He did ask me to let the court know that he was at a gas station getting his tire fixed during the interview. He tells me that he was not driving We would ask he also wants me to let the court know that he will comply with any probationary sentence issued by the court. He did state to the probation he doesn't feel he would benefit from probation, but he did tell me when we spoke that he will comply fully with any probation conditions imposed by the court. So we would ask the court to consider imposing a fines and cost sentence or a period of probation rather than filing the recommendation for 30 days in jail.
Did he do a class? I was a little confused because it said in there he did the class. Did you do a class, Mr. Buckner?
No, I've been just going to my regular therapist. But what the Mr. Lebo is saying, what he's talking about is the PSI and what I stated assertively. And I think you would be proud of me, Miss Rasheen, because I didn't raise my voice, I didn't cuss, and none of that crazy stuff I normally do.
Imagine reaching adulthood and proudly announcing that you're finally acting like an adult. Most people accomplished that milestone years ago. But don't get too comfortable, because we're only getting started. What follows is another masterclass in avoiding responsibility and blaming literally everyone else for personal decisions.
And it was 2 incidents that the probation reviewer person said to me, and I really don't want my words misconstrued. I don't want them taken out of context. He said, when he got first thing, he said, talk about the apology. And I told the probation officer, I said, if you was offended by a person, would it be more genuine for the person who offended you to apologize or for you to get a third party? Case in point, your sister stole some money from you and you feel she owes you an apology. You want to forgive her. You want to move forward in life, but she doesn't come forth. Your mother or another relative comes. Anybody that's a natural human will see that that is non-genuine at all. The officer never felt anything wrong about the way he treated me until you pointed it out. So if you would have never pointed it out, there would have never been an attempt of an apology or anything. I'm a regular human being. I try to live on regular life principles. Right is right, wrong is wrong. Like I told the probation officer, I never, not one time, did not take accountability for any of my actions. I was trying to be very clear, direct, and assertive as possible in giving my reason as to why we here today. Even during the court proceedings, you reprimanded the officer, but the bad part about it is the officer don't get no charge. I get a charge. And like I told him, life is not fair, but I will accept anything. Even though in my heart, I may not agree with it, I'm still going to accept and comply. That's what I told the probation officer. And by me saying that, that is not being defiant to the courts. It's not being defiant to anybody of authority. I just simply said, hey, I'm going to do whatever I got to do to stay free, even though I don't agree with it. That's exactly what that means. So for my words to be taken out of context, yes, I'm very, I feel very disrespected. I feel like it's a plot against me just to throw me in jail. 30 days in jail ain't going to do nothing. It's what will it benefit to remove me from my family for a phone call? What warrants that? I really would like for you, because the whole meeting was videotaped. I really would like for you to watch it, because if you watch it, you will see that I was assertive as well as respectful. I didn't disrespect nobody. I was very clear about everything that transpired during the situation. Do I feel messed up? Yes, because the officer that I made the statement towards is the same officer that's been arresting me since I was a teenager. So it is my belief, and notice I said it is my belief, that the moment the phone call came in, that officer didn't care about the threatening of the other officer. He's like, I finally got Lawrence Buckner, and I'm gonna go push this all the way up. And like I said, that's my belief. I just sat in jail for 30 some days for something that I didn't do. And like, it's a difference between actually committing a crime, getting caught red-handed, versus somebody, constantly going to jail. And this was all one big thing, because you have been my judge, named there for every case. I have lost my dogs. I've lost my business. I have lost my entire livelihood because of a woman telling a white lie, to where now I got to get transcripts from the courts so I can file a lawsuit because I got put in jail for being black, being at the wrong place at the wrong time.
Let's be clear. You weren't jailed because of racism. You weren't jailed because someone had it out for you. You were jailed because you threatened a police officer, the interaction was recorded, the evidence was presented in court, and a jury found you guilty. Those details tend to matter.
And these officers are the same officers who have been arresting me since I was 15 years old, and then want to get in front of you and act like they don't know who I am when the officer admitted in court, yeah, I dealt with Mr. Buckner in the past. Because you dealt with me in the past, that's why as soon as I called, you was instantly, oh, he a liar. I don't care nothing you got to say. And then when I respond out of feelings, out of hurt, out of embarrassment, now I get a charge. Now I want to be put in jail for 30 days. So what does it really warrant? Like, I just lost my whole livelihood. They took all my dogs because of this. Everything.
Mr. Buckner, you're yelling again.
Oh, I'm sorry. I'm my bad. My bad. I apologize. Like, nobody's taking into account of that. Nobody's saying, hey, for every action, there's an equal and opposite reaction. Okay. I didn't just get on the phone threatening nobody. I tried to be respectful. I tried to follow the chain of authority to report abuse of authority to his colleague. And what do I get? I get mistreated. I get disrespected. I didn't deserve that. And all he gets to do is get a reprimand and go about his life. He don't care about no apology. He don't. He didn't care until you pointed it out. And that's just like if you raising children and you say, go apologize to such and such. If you have to tell that child to do that over and over and over again, that child will never learn to give a genuine apology or be accountable on his own.
That comparison makes absolutely no sense. When a child does something wrong, we explain it because they're still learning. When an adult breaks the law, the expectation is that they should already know better. And let's not forget, Judge Washington didn't order anyone to apologize. The officer chose to apologize on his own. Somehow that has been transformed into proof of a massive conspiracy. That's impressive, even by sovereign citizen standards.
I was greatly disrespected, me and my family. For what? And jail, and then the prosecutor want to just send me to jail. She don't even know my life. She don't know what I've been through. Everything is just jail, jail, jail. Jail is not always the answer. Jail is not the answer. How is jail the answer? Can't nobody in this courtroom explain why jail is the answer. If I was so much of a threat and anti-government, I'd be blowing up buildings. You see me blowing up buildings? You see me starting stuff? I'm not doing nothing. The same stuff I've been doing when I came home from prison in 2020. You know, and every time I tell the courts on record, on YouTube, every time I tell the courts that I have been maliciously persecuted by Washtenaw County sheriffs for not cooperating when I got shot, nobody believes me. Nobody cares. But all these magical cases come up on me, places that shootouts happen and I wasn't even there. My GPS proves it, but I'm still in jail. Like, my mental is broke down. I have no more faith in the justice system. I am done. My life is in the last 6 months has went to crap. Okay, over a white lie. And in 2025, you would think that you could drive anywhere around the United States. But no, that ain't the case. That I was instantly stigmatized as a drug dealer, pulling up and then passing out guns. Man, my life is ruined. I worked so hard to build my dog community up. I took my dogs to the old folks home. So many people was affected by this. I took my dogs to schools. I took my dogs to help children. And now I'm so much of a threat to society to where I have to be remanded to Washtenaw County or suggested I be remanded for Washtenaw County. with nobody not even doing no type of investigation on my life. Like, I'm actually an asset to my community. I'm not a liability to my community. You put people in jail that's liability, that's not assets, that don't benefit, that don't bring nothing, that don't have no self-worth or not knowledge of their self-worth. People who have self-worth, people who making a constant effort, especially from the degrees of changes that I've made from my past. I'm doing remarkable, you know, and still and yet, like I still, for the life of me, cannot understand as to why I'm sitting in front of you. I swear I don't. You know, I try to sit about it every day. These are the same officers that pull me over every single day, every other week, harass me, and then get into court and act like nobody harassed me. Why would I call the police? I called the police on the police. So that means something had to happen to me. Something is constantly happening to me, constantly pulling me over, constantly sitting in front of my house, just harassing me, constantly coming to my house every day. Come on, come to court. Tell us she shot. We need you to testify. No, no, no. And then as soon as I keep telling them no, I get all these magical cases. Like, why won't they just leave me alone? Nobody will listen to me. Nobody. I've been in jail for over almost 2 months for nothing. I can see if I actually did them crimes. So my whole religion, my spirituality is crushed. I don't know what to believe no more. I was a very religious person, a very spiritual person, but life done beat me down. It done beat me down. And everything I think about is what happened to my ancestors. It's relevant to me because I went to jail for being black. So yes, my mindset is different. My mindset is very different. I don't know. I don't trust Europeans because a European just tried to take away my life. A European came to court and lied on me when all these cameras proved I didn't do nothing. And I sat in jail. I was tortured. I was not allowed to practice my religion. None of this. I just missed my aunt's funeral. My aunt just died. She was the only person to ever write me in prison after my mama died. And I couldn't go to my aunt's funeral because of a tether, a GPS tether that Judge Simpson ordered to be taken off. When Judge Simpson ordered to be taken off the tether, they still left me on the tether. I couldn't even go to my aunt's funeral. I couldn't even do that, but nobody's talking about that. I had a court order to take it off, and I couldn't even go pay my respects. This woman, she didn't have much. She sent me money. She made sure I had a letter every week. Every week. Tell me I love you, even though it was just the words. But nobody's looking at that. Just send Mr. Buckner to jail. Send him to jail. Jail ain't the answer.
Most people experience jail once and immediately decide they'd rather never come back. For him, it seems more like a frequent flyer program. When every setback is someone else's fault, self-improvement becomes nearly impossible, and that's how people end up repeating the same mistakes over and over again.
Thank you, Mr. Buckner. So back to what I asked initially, did Mr. Buckner ever take a course? Because it says in the report on page 2, the defendant was instructed to complete an anger management course before sentencing. The defendant completed this course, but it appeared to have no impact. I don't remember asking him about taking a class. Is all of that incorrect in the report?
Your Honor.
It's incorrect, man. It's incorrect.
All right,
And
Mr. Buckner,
and
Mr. Buckner, thank you.
please, I need to say this. The officers have been harassing me, and I really want to just make this on note that this is also evidence of what they're doing to me. And I don't know if something gonna happen to me soon, but I want this on record. You know, I don't trust the police. I think they're trying to kill me. I think that one of the police officers involved in my shooting, nobody will listen to me. And I need some help. I need some help. I fear for my life. Every day I fear for my life. Nobody will help me. Nobody will help me. And I want this on video in case something happened to me.
Thank you, Mr. Buckner.
No, I don't believe.
Mr. Pappenhagen.
That's my apologies. I mistaken. That was a mental error on my end.
I'm striking all of that from the report. Anything from anyone else before I proceed with sentencing?
Nothing from the people, Judge.
No, Your Honor.
The defendant is to complete the ABR anger management course and pay fines and court costs in this case for a total of $275. I'm gonna see him back here in 90 days on September 23rd, 2025 at 10 o'clock a.m. 180 days in the Washtenaw County Jail, credit for 11 days. The balance is suspended. So he doesn't have to do any additional jail time. If he pays his fines and costs, completes the class, and tells me what he learns from the class.
Thank you, Your Honor.
I want to say I heard every word that Mr. Buckner said. I truly believe that he is concerned for his safety. And bottom line, though, is two wrongs don't make a right, and that's why we're here. So I'll see him back here in September.
So here's the situation. There's 169 days waiting in the background. All he has to do is follow the rules, obey court orders, and avoid creating new problems. Simple instructions. The question is whether history suggests that's actually going to happen.
All right, good afternoon. We will begin in case 25M001076. It's entitled The People of the City of Marshall versus Leonard Jr. Kuseno. Is that your name, sir?
Kuseno.
Kuseno.
Leonard Jr. Kuseno.
Yeah, I keep mispronouncing it. I apologize. I forgot that I needed to broadcast this on YouTube, but we had gone through what the citation alleges, which is an expired plate, and that we're going to be you're scheduled for a hearing today. When I asked whether you wish to admit or deny, you indicated you initially wanted to deny responsibility because essentially you had a motion to dismiss. Is that correct?
Yes, I had no motion to dismiss.
And this motion was your first statement to the court was that you indicated the Michigan Motor Vehicle Code was not, at least this violation was not applicable to you because you weren't driving in a commercial sense. Is that correct?
Yes, and I'd like to ask the officer if I was hauling anybody or unloading or loading anything in my car.
Well, I will ask
That would
the
say
officer.
I
Were
was
there,
commercial.
Officer Dickinson, was there anyone else in the vehicle?
There was not.
Okay, and was well, Mr. Kuseno.
Kuseno, you got it.
I will get it right one of these times, and I'll keep getting it wrong.
Yeah.
I mean no disrespect. Okay, so I think that the officer would grant that you were not driving for commercial profit in any way.
Yes.
At least that's my understanding. Is that correct, Officer Dickinson?
Affirm.
Okay. So go ahead with your motion, I suppose, sir.
I motion to have it dismissed.
Well, on the basis just that the Michigan Motor
on why?
Vehicle Code.
Okay.
Yeah.
Yes, hold on. The enhancement caused by the commercial MVC covered by the traffic law enforcement education. Yes or no? And then the Michigan Vehicle Code Act 300 of 1949. An act provides the registration, titling, sale, transfer, and regulations of certain vehicle operations upon the public highways of this state. So the Officers Act clearly states that only certain vehicles are liable to the Michigan Motor Vehicle Code. Do you know the vehicles are liable to be regulated? Answer yes or no.
I've got to ask, is it ignorance, overconfidence, or some magical combination of both? Because the sovereign citizen strategy of confidently arguing things that aren't true continues to produce spectacular results. And by spectacular, I mean spectacularly bad.
All vehicles, well, it seems like you're reading from a questionnaire and it's
I'm
a
reading
flow chart
from,
of some sort. So the idea is,
any
here's what I can tell you.
It's court.
Here's
It's
what I can
court
tell you about the law.
constitution.
Okay.
Yeah, it's about the law.
Michigan Compiled Law 257.255, which is part of Public Act, well, the Michigan Motor Vehicle Code. I can't remember the exact Public Act number. Let me get there. Michigan 1949 Public Act 300 applies to it applies to any motor vehicle being operated on a highway or other place open to the public. Whether it's for commercial purposes, for entertainment, for to reach a destination, for any purpose. If it's a motor vehicle and it's operated on the highways, Michigan Compiled Law 257.255 does apply. And the Michigan law does require that all motor vehicles, no matter what their purpose is, well,
it doesn't. Michigan's compiled law, the Supreme Court ruled not against that.
What case was that, sir?
Hold on. Let me get it. Let me get it here. Okay, quoting from Grand Rapids, GH and MYRY Company versus Stevens, ETAL 219 Michigan 332 1922 at 337.
Okay, what does it say at 337 there? On page 3037, what does the Michigan Supreme Court say?
It says 337, a highway is a public way for the use of public and general passage and traffic without distinction. Star versus C&A Railroad Company, 4 ZAP 597. The restrictions upon the use of only such as are calculated to secure to the general public the latest practical benefit from the enjoyment of the easement. And the inconvenience must be submitted to when they are only such as an incident to a reasonable use under impartial regulations. When the highway is not restricted, it is dedication of some particular mode of use. If that is open to the situation methods and cannot be assumed that these will be the same from age to age, or that new means a making way useful must be executed merely because their introduction may trend to be inconvenience or even to injury of those who continue to use road after the same manner as formerly a highway established for the general benefit of passage and traffic must admit the new methods of use, whether it's found that the general benefits requires them and the law should prelude the adoption of the use of the methods. It would defeat in greater or less degree the purpose for which highway are established.
One of my favorite courtroom moments is when someone reads half of a legal argument online and suddenly believes they're smarter than judges, attorneys, and decades of case law. The confidence is always impressive. The results usually aren't.
Okay, I am looking at that case. The first thing I would let you know is, do you know what the Grand Rapids GH and MR Company is?
The railroad.
Right, it's a railroad. So this is a case from 1922, 103 years ago-ish. And it's a case where the Michigan Supreme Court was essentially ruling about rules and regulations on a rail that's on, like a streetcar, essentially, a rail that's over a highway in an easement. It has nothing to do with a person traveling in a sedan in 2025 on a public roadway. I understand your argument. Do you have any other kind of cases that you think actually apply to this situation?
Yes, here's another one. Each citizen has the absolute right to choose for himself mold and conveyance he desires, whether it be
Okay.
wagon or carriage,
I
by
understand.
horse,
So
motor.
I'm not trying to be rude. I might be succeeding. I'm trying to be more efficient. I think your argument is, please correct me if I'm wrong, that somehow the requirement that you have a registration plate on your vehicle is an impediment to the constitutional right to travel. Is that correct?
No,
Okay, what are you telling me then?
ordinary use on a public road. Nothing
What about
commercial.
I didn't say anything about commercial.
No, I
I
was
said,
just
are
saying
you
nothing.
trying to tell me that the law that requires you to have a registration plate is illegal because there is a constitutional right to travel?
Yes, no.
What's amazing is that the judge seems to understand the defendant's argument better than the defendant does. That's generally not a sign you're winning. If the judge can explain your position more accurately than you can, it might be time to rethink the strategy.
What-
No.
right. Okay, what are you telling me then?
Ordinary use of the public road.
Right? What about ordinary use of the public road?
A fundamental right.
The right to travel. I'm familiar with the
Yes.
argument. It's been made by others. You're not the first and probably not the last to make that argument. I have ruled before, and I would rule
Yeah.
again.
Yeah.
The idea behind the thought that it's unconstitutional to require somebody to have a license plate on their car or to have insurance or something like that is an unconstitutional violation of the right to travel is simply not true. The Michigan Court of Appeals has decided that, and frankly, that's a misapplication of the phrase right to travel because, of course, there's nothing that requires you to travel by personal motor vehicle and choose to do so voluntarily. And then if you do so, Michigan requires that you have insurance. It requires that you have a non-expired registration plate. You could still travel to Ohio or any place else you want. You could do it by foot. You could do it by train. You could do it by bus. You could ride in somebody else's car, right? But the idea is
not the
there
right to
is
travel.
no
Then.
right. It's the requirement that you have a registration plate and that it be current does not run afoul of the U.S. Constitution's right to freely travel. Now, is there any other argument you want to make about your motion?
It's just the right to use the public highway. Not to
We all
travel,
have the right to use it and the right to the right of the government in Michigan to say you can use this public highway only if you have an operator's license, you have a valid registration plate, and you have a minimum amount of insurance does not run afoul of the Constitution.
Yeah, that's not what I see the law says. That's why.
The problem isn't that the law is confusing. The problem is that some people only acknowledge laws they personally agree with. Unfortunately, that's not how the legal system works.
I understand we may disagree, but frankly, the
Yeah.
court interprets the law, and that's why I'm here. So I'm going to deny your motion to dismiss. Do you still wish to have a hearing on the case, or are you willing to admit that, on that day you did not have you had an expired registration plate on the vehicle?
No, I guess I'll have to go to court.
Okay, well, here's how this works. It's an informal hearing. So what I'll do is I'll put both of you under oath. The plaintiff in the case, which is the city of Marshall, represented by Officer Dickinson, has the burden of proof. The burden of proof in a case like this is called by a preponderance of evidence. After I put you both under oath, Officer Dickinson, who has the burden of proof, will present her case first. There aren't any rules of evidence that we have to worry about. There is one rule about the presentation, and that is that the court can consider only evidence which is relevant. After Officer Dickinson presents her case, Mr. Kuseno, you're going to
Yes, you got
present
it.
your
Perfect.
case. Finally,
Yeah.
you get to present your case. Again, you can produce anything into evidence that's relevant. And after both sides have
Okay.
presented their cases, I'll render a decision. Either side can appeal that decision within 7 days. Mr. Kuseno, if you were to appeal the decision, then you would have to put up the fines, costs, and fees as a bond pending appeal. Do you understand the process at this point?
Yes.
Okay, can you both raise your right hands, please? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Officer Dickinson
I do.
and Mr. Kuseno.
I do. I do.
Very good. Officer, if you would begin, please.
Around 7:57 a.m. on 4/25, I observed Mr. Kuseno traveling on West Michigan Avenue with a green expiration date of July 2024 on his license plate. When I stopped him, he explained that it was in storage and that he didn't have the current registration and that somehow it got missed because he was moving because Ford was buying his house down in Michigan Ave. I explained to him that I had Lean in my computer, which is a law enforcement information network, and it's connected to the Secretary of State and updated as current as their system is, and they confirmed that his registration was expired, so I wrote him a citation under the Michigan Motor Vehicle Code 257.255 for expired registration.
All right, anything further you want me to consider at this point, Officer Dickinson?
Look at you.
All right, Mr. Kuseno? Is there
I'd
anything?
like to know where I didn't have a green sticker, I don't think, on my car. It's a military plate.
Okay, anything else you want to say?
That's all I have to say, really. Except
Okay.
that, you know,
Officer Dickinson, I guess I don't know what color the plate stickers were or anything else. Do you have a recollection about whether this was a military plate or not?
I'm looking at my body cam right now. He does have a Army plate, possibly.
Is it a state of
So it
Michigan
does
sort
look
of
a little-
commemorative plate that says that
Yes,
has the
with
like
the
US
Army
symbol?
decal
Okay.
on the right-hand side. So you're right. He had no sticker that I'm seeing at all. So I must have got the July 2024 date from the computer where it says the date that it expired. I'm mistaken. I did not see a green sticker. I'm sorry.
That's all right. Mr. Kuseno, are you the registered owner of the vehicle?
yes,
Okay. And I take it your birthday is in July?
yeah.
Okay. And well, anything else you want me to consider, Mr. Kuseno?
Just consider that I had an appointment to get everything, and you know, I just got it out of storage. Isn't
Okay.
there a leeway in that?
Think about that logic for a second. If everyone could avoid registration simply by claiming their vehicle was recently pulled out of storage, then nobody would ever register anything. The argument falls apart the moment you apply it to the real world, which is exactly why it didn't work in court.
No, but I will consider it. It doesn't change whether you're responsible for the civil infraction or not, but I understand why you want to say that, and I understand that predicament. Anything else, Officer Dickinson?
No.
All right. Well, I've listened very carefully to the testimony, and it's pretty much undisputed that the defendant was operating a motor vehicle on West Michigan Avenue back on April 25th of 2025. And from both parties, but the officer had testified that she noticed that that plate had been expired. She checked the law enforcement information network. It indicated it was expired. And Mr. Kuseno has testified here today that it was a military plate. He had gotten it out of storage and he had an appointment in the future for the Secretary of State so he could make that plate be essentially not expired. Given those facts and those circumstances, I do find you responsible. It cost you $700 to get that?
Yeah, 700 and some dollars.
All right.
It was over
And
700.
And you went and paid it?
Yes. Yeah, I paid it when my appointment was up.
Well, in light of that, I do find you responsible, but instead of assessing $110, what I'll do is assess $90 because I think the Secretary of State penalized you quite a bit financially.
Yes.
But I do obviously have to enforce the law as it's written. So what I'm going to do is indicate that I'm finding you responsible. You'll have to pay $90. Total fines, costs, and fees. Can you have that paid by July 15th, or do you need more time?
Yeah. You got to get to Battle Creek. I moved now, so I'm ways away.
I believe they have a way you can pay it online now, or you can pay it in the mail.
Oh,
If you
I
use a
can do
credit card,
that, yeah.
yeah, if you use a credit card, they'll add a credit card fee. But do you want me to give you till the end of July? Will that help?
Yes, can they send a check to him, a personal check, or no?
Yeah, you can. Basically, when you get a copy of the judgment, if you have any questions about how to pay it, you can call the district court clerk's office, which is the same number you
Okay.
called originally to say you wanted an informal hearing. Does that make sense?
Okay, yes, do you have my right address now?
Is that correct?
Yes,
All right. Basically, what's going to happen is I'll draw up a judgment. It'll go out in the mail tomorrow. It'll take a few days to get to you. Just make sure you have it paid off by July 31st, okay?
okay, thank you.
You're all set for today, sir. Have a good day.
And that's where we'll wrap things up for today. A big shout out to Old Squishy Gardner for finding and sharing these courtroom gems. Tracking down these cases takes a lot of time, and creators like him help keep this corner of YouTube entertaining. If you enjoyed the video, hit the like button. If not, hit dislike. But either way, let me know what you think in the comments. And if you're new here, subscribe and turn on notifications so you don't miss future courtroom disasters. Thanks for watching, and I'll see you in the next one.